So let's start, and let's begin with item number 33, which has been pulled by three folks and have two members of council that have posted potential amendments. Councilmember Alter.
Good morning. Thank you for recognizing me, Steve. This weekend, three religions celebrated very important holidays. And in light of the holiday weekend, I chose not to weigh in on the message board, but I do want to share my thoughts with you this morning. I really appreciate the conversation that we're having. Last year, while we waited for a decision on Acuna, we decided collectively as a council to try to move forward with land use changes that were consensus-driven, or at least could garner support of 9 of us. I continue to believe strongly that a consensus approach is the best way forward. Now that we have one of these proposals back for review, VMU2, and some breathing space, given the trajectory of COVID, I believe we have an opportunity to build trust among ourselves and the community and to forge a consensus that ties increased density on corridors with real gains in affordability. This morning, I would like us to focus first on the appropriate process for moving forward with changes to VMU and or compatibility, and more broadly for how we want to add further density to our corridors tied to affordability. I do not believe that we can do the work that needs to be done on either item in the 2 days we have left until our meeting. We have an opportunity that if we take a little more time, we can achieve something of significant magnitude as a council. I also do not believe 1 week's notice about compatibility being fully on the table for VMU with a holiday weekend for 3 major religions in between represents the kind of conversation expected in Austin for a decision of this magnitude. I also think this is a discussion that really merits a full dais. I worry that rushing ahead this week will undermine trust in and between the council. Thus, I would recommend a postponement of item 33. The mayor and I have conferred on the process and have some ideas of how we might be able to move forward that I want to share with you and get some feedback on what you think about it. In our conversations, we were hesitant to simply delegate this to the Planning Commission. Instead, this really does feel like work that we ourselves need to undertake. It seems that we have often had to have conversations that are rather absolutist, like either or. And in an effort to maybe think if we can get outside of those boxes and really have some conversations, building off a foundation of good ideas that are out there, building off of work that has been previously done by the Planning Commission and all sorts of other groups, what I want to throw out there for us to consider is maybe we break up into some smaller groups of council members with a deliberate effort to have council members who are not normally voting on the same side of land use votes combined in those groups to have these conversations and tasked with coming back with options for all of us to consider. I think because there's so much work that has been done, if we focus and we sit down and have some of these smaller conversations, we could have an initial get back together and throw out options at the May 17th work session and decide from there kind of what the appropriate timing would be. We have done a lot of this sort of either or kind of stuff, and I think that we really need to focus on what we agree on, which is adding density to the corridor and tying that to affordability. I think there are plenty of different ways that we could go about doing that. And I think in this way, then we can build in a process for the community also to be involved. But I think that this may be a different way than we've approached this, and one that I believe offers promise for us to arrive at some significant forward momentum for addressing a concern that was identified over and over again as consensus that we broadly want to address the problem. How we have disagreements, how has to be figured out. The details do matter, and concerns in different districts do need to be surfaced in different ways. So that was the idea that I wanted to throw out there and that the mayor and I had discussed. And I hope that we could consider thus postponing VMU indefinitely, but setting a path forward to have the conversations that we need to have about compatibility together.
Just to jump on that real fast, Mayor Pro Tem, thank you for your suggestions on this and for visiting with me on what might be a really constructive path forward. I want to thank Councilmember Kitchen for the work in bringing up the VMU. I want to thank Councilmember Vela for bringing up compatibility because those two are so tied together in terms of what actually happens on the ground. It seems hard to have a conversation about one without having a conversation about the other. But I do agree with the Mayor Pro Tem that even though there have been 8 years talking about this, even though there's been a lot of work, even though there are a lot of proposals out, we can't. I don't think it's right for us to act this week. And I think that if we talk to each other and follow the process that the Mayor Pro Tem set out, I think we actually have a chance of doing something that advances this in a way that would be right. I think the community is now expecting leadership from us to do this. On the posting, I kind of laid out some questions that I thought that would be good questions to answer, some of them here today, some of them over the ensuing weeks. But the schedule that the Mayor Pro Tem laid out has us being able to take action in the next 30 to 60 days, has us coming back May 17th, potentially daylighting suggestions. I like the idea of people being able to break into groups. I love the idea of breaking into groups that you don't ordinarily break into because we're trying to do something different here. And everybody in those groups could set up community engagement processes or open up meetings or make it as involved as you feel would be appropriate or as the community would expect. But on the 18th, then we could all get back together and say, okay, these are the ideas that have bubbled up from the group in terms of things that we might be able to proceed with agreement on. And I think that's the goal. That would give us, yes, because I think we've done.
Just to clarify, as we're talking, this community engagement would happen within the next 3 weeks. We would design a process and do this community engagement and come back with proposals in 3 weeks. Is that what the suggestion is?
I think we're asking people to kind of elevate and bring ideas back on the 17th. I think different people could do different kinds of community engagement. And I don't know exactly what that would look like, but I don't think we're limiting people's ability to do that, nor necessarily requiring that it all be collective. Don't know. I mean, I think that's the kind of thing we should be talking about here on the dais, because I don't think we've formulated that plan. But what is important to me is I want this to come back to the council within the 60 days so we can take action before we leave for summer break.
So, Mayor,
the second thing, let me finish and then I'll come to you next then. The next thing that I think would be important to me is that the conversation be about corridors and about increasing density on corridors. And I think that the conversation should include and be primarily on affordability, but allow for a broader conversation. And with those two things in mind, I think that we're in a place to be able to move forward, not take action today. Ann.
Thank you, Mayor. And I also want to thank everybody that's been involved with this. Thank you, Mayor Pro Tem, for laying out a process that you and the mayor have talked about. I also want to thank Councilmember Vela for bringing up compatibility. We've had some conversations about the importance of addressing compatibility. I support and have talked about it's time to have the conversations with the members of our community, all of us with our community, to have that community conversation, to vet what works. And I think we're all in agreement, because we've talked about it from time to time. We're all in agreement that we do have an opportunity to forge a consensus in conversation with the community, how can we best get affordability on corridors? I mean, I think we're agreeing on that. And how can we do it timely? So I think we're also agreeing that it's time to take action. So, I think that I agree with what Mayor and Mayor Pro Tem have said, and I think others would probably agree that that we need some time to vet. That 1 week's notice that we're now going to talk about compatibility isn't sufficient, but that's okay. We can take the time to have the conversation and to figure this out. You know, as I brought forward with my colleagues, and we all supported this back in November, as I brought the conversation forward around VMU, we talked about how important it would be to look at this, what's been a successful program, and look at it and see what we could do to improve it. So I'm glad that we're having that conversation. I recognize that there's a number of things that can improve it. I'm ready to have that conversation about compatibility with the community, and so I'm looking forward to moving forward with that. I do want to say that I think what would be important to do today, and I'm going to ask Law to answer some questions for us, is we need to, one of the things that's critical for us to understand, us and the community to understand in order to go through the process that's being suggested in a meaningful way, is we need to have a conversation and understand what our parameters are with regard to how we address some aspects of this. So, Mayor, you had laid out one question, and I think the way you styled it is, should VMU2 be handled as a text amendment to the VMU zoning classification or as a newly created district? That question really ties back directly to the parameter that's set for us from the Acuna ruling. And so we need to understand, and the public needs to understand what the parameters are that are set by that ruling. So I have a question for Law today to talk about publicly. And so I understand that Law will be here. And so I'd like to ask that question right now. So we can have that conversation. And what that will do for all of us, it will help us understand what our parameters are so that as we're brainstorming and working with each other and working with the community, we can understand how we need to set up these amendments. And this goes back directly to the amendment that I had proposed that related to treating this more as a newly created district, which just means, which goes to when and how notification and protest rights apply, which was the one of the tenets behind the ruling. So I had proposed one way to do that. I am open to talking about other ways to do that. So, but I think we need to understand the parameters. So I'd like to pose a question. I don't know if that will be who from our law department. Hello, thank you for being here with us. Here's the question I wanted to pose. I want to understand, my understanding is that the Acuna ruling set parameters for the city related to notification and protest rights. So I want to understand what the court ruling says and how that impacts any changes we're making with the LDC. This is the first one that's coming up in front of us, so it's timely for us to understand that. And I want to understand the difference in how we handle notification and protest rights between treating changes as a text amendment or treating them as a newly created district. And if I haven't styled that question in the correct way, please help us understand how we should think about it.
Trish Link with the Law Department. I do have a couple of slides. If Avi could put those up for
Okay.
me, please. Actually, mine is the notice and protest rights.
Ms. Link, please give me a minute to retrieve that presentation. This is the only one I see right now.
So, Mayor, while they're doing that, I think you mentioned this on your message board post, and I think for the public that may have missed it, my understanding is that the city will not be appealing the case.
Two things. I haven't heard any suggestion that the city would.
Okay, great. I just wanted to
appeal the
confirm
case.
that. I think you had written that on your message
Right.
board. Okay.
And while we have this break and the attorneys are coming up, Councilmember Tovo, I think I poorly answered your question when you asked me a second ago. I wasn't meaning to suggest that the only public engagement needed to happen in the next 3 weeks, but certainly it wouldn't be precluded. There's a month after May 17th before we take a break to be able to fully engage the public on any of the suggestions that surface. I was thinking in terms of, are people precluded from doing public engagement over the next 3 weeks? The answer to that's no, but there's certainly time after that.
I think this bears a further conversation. You know, usually when there are conversations around land use, our city staff actually help with that community engagement. I think asking council members to conduct reasonable, authentic, sufficient community engagement around an issue that we know has been controversial within 3 weeks is just is completely undoable.
And that's why I
I'm
was
not
trying
sure
to
several
correct it,
council
'cause I
members
wasn't
could even,
implying-
excuse me, I'm not sure several council members could even align their schedules within
Yeah.
that 3-week period. Never mind mount any
Yeah.
level of significant
Please
and
don't
authentic
present that as an
community
obstacle, because I
engagement.
wasn't suggesting that.
I
I
think
started
it's
off
gonna
by
be a-
saying I misspoke.
Mayor,
But-
Steve, you're speaking
Okay.
over me.
Okay.
I think that we need to talk about what a reasonable community engagement is like, even if it's not within 3 weeks, and the level of staff support we're going to have for that. Having participated in the VMU process initially, I mean, there was significant staff support, and I think there needs to be, just as
agree with
there
that.
was with our LDC conversations.
I agree with that 100%. Okay, let's do this, and then we can come back to talk process and hear from other people too. I'm sorry, Trish.
Can you take me up to the top slide, please? Or the second slide, actually. Okay, next slide, please. So under the decision in Acuna, the court is looking at state law. And what we are kind of moving forward with is the type of notice that's required. So that's one element. And then there's also the protest rights issue. And these are, I think historically we've thought of them kind of connected together, but under state law, they actually act independent, and they are independent of each other and separate. So that's how we have to, I think, kind of slowly start to retrain ourselves to think about them differently. Under state law, the published newspaper notice is required for a change in property classification, or even when there's not. So that would be a change to a zoning regulation or a zoning boundary. State law also requires an individual written notice when there is a change to the property classification. And the classification, as we typically think of it here in Austin, is the zoning string. So if you're changing from GR to CS, that's going to be a property classification change for us, typically. And then the next slide, please. And then there's protest rights. Well, basically the bottom line, anything we do when it comes to zoning, there's a protest right. And it's a change to the zoning regulation, a change to a boundary, or a change to a classification. And again, that's our routine zoning cases that we see on a day-to-day basis. What is different, though, is the denominator for this situation, for the protest rights. Next slide, please. So the denominator equals the area covered by the proposed change, or the area within 200 feet of the area covered by the proposed change. And it really will depend on the nature and the scope of the proposed change. And I can show you that in some examples on the next slide, please. So for an individual rezoning case, owners of 20% of the total area of the property covered by the application can protest. Typically, we don't see that in an average case because they've come to the city asking for the rezoning. But we could have that situation if we do a small area planning, if we do a neighborhood plan. Also, if we, that comes up actually in historic cases. But what we typically see in the individual rezoning cases are owners of 20% of the total area within 200 feet of the property covered by the application. So that's what we see on a pretty regular basis, is that question comes up whether or not we have 20% of those, the neighbors. For a text amendment, which for council's consideration on Thursday is a text amendment to our code for VMU. So for a text amendment, owners of 20% of the total area in the city with a V designation is the denominator. Alternatively, if 20% of the owners of the total area within 200 feet of all the properties with a V designation, that could also be our denominator. I think our, with something like V, so the way the ordinance is in backup today, that denominator is going to be all of the V properties in the city. To meet the 20% threshold is actually going to be quite challenging. With the proposed amendment from Councilmember Kitchen, just using that as an example, it's creating the paper district. Nobody has the V2 that is being created. And so there is not really a denominator. There's a protest right, but there's not a denominator because nobody's subject to it. But if council adopted that paper district, when someone comes in to apply for that district, then we will have the 20% where we will be looking at probably the neighboring properties because the owner would have come in likely to ask for the zoning change. And so the 20% wouldn't be necessarily an issue for the owner, but it would be for the surrounding neighbors is what we would generally have to look at.
Thank you.
I have
Kitchen.
two very quick follow-up because I'm sure others may have questions too, so I'll leave time for others. Okay, so let me just make sure I'm understanding. So for a text amendment, which is a change to the code that doesn't actually, let me ask you this. A text amendment changes the language of the code, but doesn't actually attach the change to the property? Is that how we defined a text amendment?
So a text amendment is a change to the code itself, not someone's zoning ordinance for their property.
Okay. So in this case, and then the second question I have is, so you had, you told us that protest rights apply, but the individual notice, so the individual written notice does not apply to a text amendment, is that correct?
Correct.
Okay.
I'm going to say yes, but there could be a situation that council takes on that could have the potential for it. So I'm not going to say absolutely in every situation, but generally speaking, yes, the text amendment is going to be the published notice, but if we change the string on the piece of property, they would be entitled to individual written notice. Okay.
So talking about the VMU, so in this case, a change to the ordinance itself is a text change that doesn't require individual notice. And so then I get to the application of the protest rights. So in the case where we have the amendment that I brought forward, which establishes that the change would apply as part of a zoning process, in that instance, protest rights and individual notification would apply at the point that someone wanted to make that change to their property. Is that right?
Correct.
If we don't attach the language that I suggested, then we can still make the text change. Well, tell me what happens if we don't apply that. How does an individual get notice that their property could be considered for change, what happens if we don't? I'm sorry, I'm not being very clear. I have been thinking that in order for an individual or folks living around a property to have individual notice and property rights, we have to include in our ordinance the establishing it as a zoning process.
For a text amendment in the scenario for the ordinance that's in backup today, that the council has on the agenda for Thursday, the opportunity to protest is now.
How do they know to protest?
That is something we're going to have to work on as an organization going forward.
Okay, so they wouldn't, so for example, they wouldn't know, we have not as a practice given individualized notice in a text change. And so while people theoretically may have the opportunity to protest, we haven't yet figured out how to give them notification. Is that what you're saying?
We've given them notification. We haven't educated the community about the protest right.
But we haven't given them individualized notification.
Correct, but the individualized notice and the protest rights are not synonymous. So
Okay.
you can still have the protest right for the ordinance that is in backup for
Okay.
Thursday. It's just not something we've educated the community on, and that's what we will have to work on going forward.
So the challenge there is how is the community to understand that they have a protest rights in the instance where we're making a text change, because the notice to the public of the potential text change comes in our normal process as a newspaper publication notice and the other ways that we put things on the agenda. So that's one of our questions, right? Did I say that right?
So going forward, if the council would like staff to include that language about protest rights in the notices, we can do that. Council could also direct for the manager to add something to the city's website, to do outreach and those kinds of things to help educate our community about the protest right, yes.
Could we also decide in circumstances for text amendments to provide individualized notice? If we're making a text amendment that doesn't impact the entire city but impacts parts of city, could we also choose to say we're going to give that individualized notice so people actually know what's happening next door?
Yes, council can make that decision.
Okay. All right. So then the last question I have, because I know others may have questions too, with regard to the protest rights. So if I want to make sure I'm understanding you correctly, so that in the case where we're doing a text change and we're treating something as a text change, we are calculating protest rights in the aggregate so that all properties that might be affected are the denominator, and 20% of people that meet that requirement, the 200 feet, for all of those properties. Wait, I said it wrong. I'm sorry, I got the math wrong. Basically, it's in the aggregate, right? So what that means is if you have a text change where you are impacting 10 properties, for example, and you only have people protesting one of those properties, they won't be meeting the 20% because their math is calculated for all 10 properties. Is that correct? You could have a situation like that.
Could you do your hypothetical again? I
I'm trying
apologize.
to explain, and I'm not doing a good job of it, so you maybe do a better job of it, but I'm trying to explain what we mean by doing the protest calculation in the aggregate. That's the way that I can think about it. So what that means to me, and I think you have a slide that explains it, but basically what that means is if we make a text change that impacts a certain number of properties, I'm just going to use 10 as an example. If we have a text change that potentially impacts 10 properties, the protest rights apply for the owners of those 10 properties. I'm going to set that aside at the moment. The protest rights also apply for for people who are living, or I guess owners, who are living within 200 feet of that property, okay? But they have to reach that 20% threshold. So our denominator is everybody that's living within 200 feet of all 10 properties, and our numerator is the number of people that protest, so it's got to equal 20%. The issue with aggregate is we've created a denominator that doesn't look at protest rights for each individual property. It looks at protest rights in the aggregate across all 10 properties. So if you have a situation where your text amendment impacts 10 properties and you only have one property that people are raising questions about and have protests, the fact that you don't have any protests for the other 9 dilutes the 20% for the protests for that one. Am I understanding the math correctly? I didn't mean to use dilutes in a negative sense. I'm just trying to understand the math.
So if council passes a text amendment or considers a text amendment, and you have multiple properties that
Right.
have that particular designation. So in our example for VMU, it has a V designation.
Right.
All of those tracks.
Right?
So when you take all of those tracks together, that is going to be your denominator. So you need 20% of those owners, or you need 20% of the property owners within 200 feet of each of those of the total properties.
Combined, right?
Combined, yes. So
Okay.
it is a much larger denominator than we traditionally see in an individual zoning case.
Okay. So protest in one part of the town, and no protest in other parts of the town can impact whether the 20% is met.
I think that's likely.
Okay. All right, I need to let others have I apologize, I just wanted to get really clear to make sure I was understanding it. So I will, I may have other questions, Mayor, but I want to let others ask questions.
Thank you. Councilmember Alder, Mayor Pro Tem.
Thank you. I have a quick question for Trish, and then I want to clarify sort of how I was thinking about the process that we talked about earlier. So with the notice, the newspaper publication for a text change, that's what's required by the state. But there's nothing to preclude us, as Councilmember Kitchen suggested, of saying in any given case that we think we need more notice, or broadly saying we want to have more notice.
Correct. Council
individualized
can
notice.
direct for additional notice, yes.
Okay. Will there be a memo of some kind forthcoming with some examples and some way for the community to better understand how legal is suggesting we interpret the ruling in terms of how we are acting moving forward? Because at this point, we just have our legal department's perspective on that. And you know, we had talked about this particular vote has precipitated that, but we had talked about the need to be transparent here. I appreciate you being ready with the presentation and all of that. I just wanted to see if something would be forthcoming that would, for people who are not able to come and, you know, watch this, that they might be able to access a memo of some kind.
Yes, Councilmember.
Great, thank you. So I wanted to just, I don't know if people have more questions, if you want to stick on that first. I don't.
Let's stick on this first while we have a turn here, and then
Okay,
I'll come
that's
back
fine.
to you to help clarify my misstatement earlier. Yes, Councilmember Kelly.
Oh, I didn't have questions for legal. I just wanted to talk about the
Okay.
item, so somebody
Let's
else
stay
can
with
go.
legal here for just a second while we have them in front of us. Yes.
Thank you. So just so that I'm following this conversation correctly, you mentioned that the VMU2 ordinance, which is on Thursday's agenda, does come with a protest right for the community. City of Austin has done a public notice, so we're in compliance with the state law for public notification. However, I wanted to dig in on the denominator for this Thursday's ordinance proposal. So the denominator for the VMU2 text amendment would be all of the properties that would be subject to the change of, I guess, of the new classification of VMU2. Is that correct?
So it would be for either proposal that council considers or adopts will have the protest rights associated with them. Because what council is voting on this week would be a text amendment, regardless of how it's kind of set up internally, it's still a text amendment to the code. And so the denominator will be the 20% of the total area of the properties covered by, that have a V designation today. So that's the one denominator. So if you got 20% of those owners, then it triggers the three-fourths vote. However, there's a second denominator, which is going to be an even larger denominator, which is the 200 feet surrounding each of the properties. So if you take that total area within 200 feet of all of the properties with the V designation, if we got 20% of those owners, that would trigger the three-quarters vote. For the ordinance, that is a text amendment.
Right. And so the options, go ahead. The options that we're considering between the two is the current ordinance proposal is for all V classified properties throughout the city. And Councilmember Kitchen's proposed amendment would then change it to be within not only all of the V properties, but also properties within 200 feet of the V properties.
It would actually be, so both are the denominator. What Councilmember Kitchen's proposal does is kind of adds a second layer. So it's not, the way the ordinance and backup works is it is an administrative designation essentially. So if you are going to provide the amount of affordable units set out in the ordinance, then you would be classified as a VMU2 and you get the 30 feet of height. Mm-hmm. And that would be done administratively based on the draft that is the staff draft brought forward. Councilmember Kitchen's ordinance proposal will actually create this, I'm calling V2, because if you look at the last page of the motion sheet, we've designated it as V2. So it would create this paper district of V2. And so that second step is nobody would get that administratively. They have to come and ask council to get the V2 added to their string.
If I could clarify.
Hang on a second, just so that we get turns here. I understand. Let me see because I think that the Mayor Pro Tem's question about getting something out to the public so people understand why it's the interpretation, what the law says, I think will also help people be able to apply it. So at a really high level, my understanding from my conversations with you is that what the law says is that 20% of the people impacted by the council action form the universe of 20% of the people impacted by the council action is the group from which you have to have, the group that's entitled to file the appeal. So you have to be in the universe of people impacted by the council action. So if the council action is just to zone one property that way, then the only people that are impacted by the council action is that one property and the people around it. Mm-hmm. If, on the other hand, the council action is to impact all of the V properties, mm-hmm. then the people that are impacted by that council action would be everybody who is around any of the V properties mm-hmm. anywhere. Mm-hmm. So council can either decide to take an action that says tomorrow, or as of when we take our vote, mm-hmm. every V property, this is the rule, in which case it impacts all of the V properties, and the universe of people is everybody that's within 200 feet of any of those V properties, because they're all impacted. Mm-hmm. So if you want to get 20%, you have to get 20% of all the people impacted. On the other hand, if what the council does is say, we're going to create this VMU2 district, we're not applying it to anybody. We're just creating the district as a tool in a book. Nobody's impacted at that point, so nobody has any appeal rights. But the day that a property owner comes in and says, I want you to give me that VMU2 designation, if the council does that, then the action taken by council is to impact that one property. So therefore, the people that would be able to file an appeal or a protest are the people within 200 feet of that property. So my understanding is that the measure that is in front of us, and in fact, the measure in all fairness that we asked staff to bring back to us when we passed our resolution last November, was to give us something that impacted all of the VMU properties. Therefore, if we pass that, then everybody within 200 feet of any VMU property is part of the people that are affected. Councilmember Kitchen's amendment says, rather than doing that, let's just give VMU2 to one property at a time, and because we're giving it to one property at a time, the universe of people that would be impacted would just be the people around that property. Is that, did I state that correctly?
Yes.
Okay, thank you.
So Mayor,
Councilmember Kitchen.
thank you. That was articulated better than I was trying to articulate it. But let me just explain the reason that I brought the amendment is because I am concerned about the interpretation that we have to look at protest rights in the aggregate. So that's the reason. And yes, we did start down this road with what is essentially administrative attachment of V2. That was before the Acuna ruling. So what I brought forward was because it was the only way I could figure out to actually give meaningful protest rights, because I don't think it's meaningful protest rights if you're counted in the aggregate with everybody else in the city. So I have one last question. So we got some clarification, and thank you, Mayor Pro Tem, for that. We got clarification that, that the council could choose to do additional notification or notice rights. So my second question, could the council choose that in circumstances like V, that we want to calculate protest rights as it applies to a particular property when we do a text amendment, as opposed to in the aggregate? I'm understanding that legal's interpretation is that we only have to do it in the aggregate, but could we not choose to do the math in such a way that it's not in the aggregate, which would have the same impact as what I was trying to achieve with attaching, the one by one that the mayor explained. So this is just something that we all need to understand and think about, because perhaps you could give meaningful protest rights to individuals around a particular property if you did the math differently as part of a text amendment. So anyway, I'm not proposing that at the moment. I'm suggesting that we think about that, because I know that one of our concerns that folks had about actually having to go through a whole zoning process to attach V2 is concerning for folks, and I understand that. And that's why we made it administrative to begin with. So I think we should give some thought, and law, you may need some, law, thank you. Legal may need some, you may need to confer and consider whether we could do that. But that's a question that I have on the table is, could we choose with the text amendment to do the math differently and in that way achieve the same thing that I was trying to achieve with an amendment that requires a whole zoning process? So I'll leave that on the table for people to think about.
Sorry. Thank you for that. My hope is that we can get to a conversation about process, right? Rather than, because I think there'll be people that disagree with you substantively on that issue, but that can be part of the conversation as people go off, for several weeks and then come back and talk to the larger group, and then thereafter have larger community involvement. But if we're not going to, it might be helpful just to know at a really high level where people are, just so colleagues can hear where people are at a really high level substantively. But my suggestion is let's find out if procedurally the way we want to proceed is to postpone the conversation substantively, to give people a chance to work, and then to come back. I'm going to go to the Mayor Pro Tem because I cut you off before, if you want to say something.
Yeah, I just wanted to go back to the process and clarify what I had in mind, and as the mayor mentioned, I think he said he misspoke. So when I mentioned the date of May 17th, that was merely to say, I think that we could have a touch back as a full council on where the different groups had come up with options and share the options and have those discussions. When the mayor and I talked about process, it would be a little bit premature, I think, to go out to the public and try and have big public meetings because we have no idea where we're landing at this point. But we were trying to figure out, do we delegate to the planning commission or do we not? But these groups would allow us, in terms of sort of the broader engagement, these groupings would allow us to engage our own commissioners in discussions to get the benefit of their knowledge and expertise. And if any council member wanted to have broader conversations with the public in an open setting, they wouldn't be precluded from doing that. But we really wouldn't know where we were landing until we began to come back as a group and we considered sort of the options. And part of the notion of putting folks together who don't normally stand together is to try to find some of those middle ways. We have some things that have been put out there by prior planning commissions, which would be good places to start, and really trying to interrogate those and see if we can land on something. And then, the way that I had stylized it, when we have to figure out what the appropriate process is at that point, if we're in vehement agreement that we can land on something, then we can move faster. If we're still not there yet, we may feel we need to have more modeling. We may feel like we need to do more steps. I don't know that until we actually do the exercise of deeply engaging on that process. But I do not believe that I nor the mayor had fully laid out what the community conversation would be, and I think we do have to, I'm thinking about this as a discussion of the corridors, not just VMU. But if we were only thinking about corridors, we certainly would need, if we were only thinking about VMU, then we would certainly need to recognize that some districts have more VMU zoning in them and might require more conversation to get to the finish line than others. And I don't feel like I've resolved that as the process. I think it's an important question that we have to think through and address. I just know that we are not ready to make these decisions, in my view, this week, and if we do, we miss an opportunity to make more significant changes where we can tie any density increases to affordability and really achieve the goals that we all agree on.
I appreciate your help with the clarification. Councilmember, okay, Kelly.
Thank you. On item 33, I agree with the postponement. I also agree that we need the full dais here in order to honor all of us in each district to get them involved in the conversation. The community does need time to digest the amendments and get community feedback. We need that as well as being council members. My understanding about 9 votes for consensus about land development code changes is important. I really feel that we need to have that, especially coming out of the most recent lawsuit. I like what the mayor said about corridor density. It's important for both growth and affordability. And I believe as a council, we need to rebuild trust in the community about these discussions and decisions that we're having. So I'm looking forward to hosting a town hall in my district to talk about these issues. Thank you very much for the postponement.
Thank you, Councilmember Vela.
Well, I really appreciate the discussion, and I appreciate Councilmember Kitchen and Mayor Pro Tem Alter's comments. I agree with him. My only addition would be a sense of urgency with regard to these changes. There's another, the tenant relocation ordinance is going to be on Thursday, and that stemmed from an eviction, a kind of a forced eviction that was going on in my district. And when we were talking to the folks that are being forced to relocate, they were saying they cannot find apartments in Austin. I mean, they were, let's say, given to like April 30th, and they were, took a couple of days off work to go look for apartments, and they were like, maybe like late June we might have something. I mean, the situation is really critical. I think all of our housing indicators are very negative at this point. I mean, where you're talking about rent increases, you're talking about appraisal increases, you're talking about vacancy rates, you're talking about just, I mean, the number of single-family homes, even if you're a purchaser. And I just hope that our reaction and our response as a council to the housing crisis that we're facing, as Councilmember Fuentes noted, is matches the scale of the crisis. That I think that unfortunately the time for kind of smaller changes and tweaks has kind of come and gone, and the scale of the crisis is such that the corridors and the density, the number of units that can be built along the corridors is where I think we can give our renters some breathing room, and potentially, honestly, home buyers as well. And just one more comment. I think that ultimately the work of a VMU type zoning, of expanding it, dovetails with Project Connect. If we're going to have a successful quality transit system, it has to be surrounded by housing. And the discussion that we're having, I think, moves us in a very positive direction. It moves us toward a much more successful, a much more affordable, a much more sustainable, environmentally sustainable city. And so I appreciate it. I enjoyed the message board comments. I thought they were all excellent. And I look forward to working with everyone to do something positive.
Great, thank you. Colleague, yes. Councilmember Torilla.
Thank you, Mayor. And I agree with my colleague, Councilmember Vega. On three of the corridors that I have indeed three, which is South Congress, South First, East 7th Street. We have built over 2,500 units there. Only 254 are income restricted at part 60 and part 80%. With B2, and I've gotten a lot of criticism for that, because a lot of the community there have been wanting more affordability, in order to give them the bonus that they've been asking for. And they're saying they're not enough affordability there. And we're having a lot of our residents are really struggling when a one bedroom apartment is $1,500 and 2-bedroom apartments is $1,900 a month. That's not affordable at all. And with the VM2, we'll be able to get 12% at 80% ownership, and rental we'll get 12% at 60 for 40 years. Or 10% at 50 for 4 years. I mean, this is the thing that we need to start working on quickly. And I hope that we can get our differences over and settled, so that we can get this city moving on building more affordable units. I mean, we're really struggling. I mean, it's sad out there where people just can't find a way to go. I mean, move to. I mean, there's nothing available. And if this is the kind of city that we want to build, that we're all going to be competing for a house or an apartment, and paying top dollars for something where you're going to end up having to pay more than 30% of your income just to live here in Austin, and we're doing a great injustice, to our city. So let's work together. I support, delaying it until everyone gets the feeling that, they're more educated on this issue, because we're really struggling right now, and we need to get something done.
Councilmember Harper Madison, then Councilmember Ellis.
Thank you, Mayor. I appreciate it. I just want to echo the sentiment of both Councilmember Vela and Councilmember Renteria. I'm really just very happy that Councilmember Vela had the courage to bring this item forward. We all know that this is going to be a tough conversation. I look forward to having it amongst ourselves. But we all know that Austin is experiencing a severe affordability crisis. And, you know, coming in, I came in on the tail end of the conversations around Code Next. We spent 10 years talking about rewriting our land development code to allow for more types of housing and for more kinds of people and, you know, all parts of Austin. While that process, you know, featured a ton of community conversations, I myself, you know, as a layperson, attended multiple community engagement conversations and gave feedback. One of the clearest, most well-defined pieces of consensus that came out of all that was our city is prepared to accept more density along the corridors. The median home price in Austin is topping $600,000. That's $600,000, $200,000 more than it was 1 year ago. 1 year ago. I mean, the impact of that is felt so deeply by so many people. I really appreciate Councilmember Renteria's commentary. I have people that are calling our office every day that just are hopeless. They have nowhere to go and they can't afford to live here. In which case, I think we need to do everything we can to make more room for more people. I think residential property appraisals just jumped 56% over the last year. I just keep thinking about, you know, our working class and our middle class Austinites. You know, it must feel like we're up here just fiddling around while they go looking beyond the city limits for housing they can afford. Teachers, firefighters, baristas, musicians, police officers, nurses, bus drivers, they're all getting priced out of Austin. We've long been economically and racially segregated, and we're only letting that get worse with our inaction. I think the status quo is broken. It broke a long time ago, and we're all paying the price for not fixing it. I think this ordinance won't be the silver bullet, but I think passing it with council members, with Councilmember Vela's amendments would signal that we are finally ready to take some action, to respond to consensus thought on density, also while reimagining some of the outdated rules that have led to our current crisis. I'm not sure what the value is in postponing, so we can have more discussion and more input. I think we've done that for the past decade. While I'll respectfully, you know, follow the lead of my colleagues, I'm happy we have, however, to wait until we have all members on the dais to weigh in on it.
Thank you. Councilmember Ellis?
Thank you, Mayor. I think this vertical mixed-use conversation is an interesting case study of what the Acuna decision has come out to say and our legal staff's interpretation of exactly what types of notification and protest rights are going to apply to our zoning cases moving forward. That being said, I do see there's a benefit in predictability. You know, when we tell people that we need certain community benefits in exchange for certain types of zoning, it's extremely frustrating to see some of those packages are different from case to case, zone to zone, you know, council district to council district. And the truth is that we do need more housing. I'm also shocked by the increase in the average cost of home ownership in this city. There are city employees that can't afford to live in this town anymore. And it's something that we need to take very seriously. I know a lot of us have worked on this topic in many different angles over many different years. The truth of the matter is there is an urgency in doing something to bring more housing into this town so that the folks that give their heart and soul to this community feel like they have a place to live and that they can stay here inside the city limits as well. I would lean more toward having a date for a postponement, just simply so that we can provide proper notice. We can always decide at that point in time whether we need to take a vote at that moment or if we need a little bit more time to work on some of the details of this particular plan. But I do like the idea of giving it about another month for us to have these conversations and to be able to educate the community, whether it's ourselves and city staff, to help us make sure we're relaying the actual information and it's accurate and everybody's understanding the exact same process moving forward. The idea of being able to do, kind of blanket notifications and having a different universe for text amendments is a new concept that I don't think we've, really worked through as a dais or as a city staff. But I do think predictability and certainty so that when people want to build homes in our community, they're not spending years to say, is this going to work? Is this not going to work? And some people get to the dais and they get, a blessing, and sometimes they get to the dais with the same package, and it's not quite enough for the community that surrounds it. So I see a benefit in having consistent expectations of what these new notification and protest rights are going to mean, but also a predictability in exactly what packages are going to get approved by the dais, especially when we approve resolutions and have board and commission input. I want to make sure that all of the public input that's happened to that point is consistent and we don't switch gears at the last minute, because I think that creates a lot of frustration in the community and further sets us back on our housing goals.
Councilmember Tovo, did you want
Well, I have questions for law, which is going to take us backwards. I didn't realize we were switching from that, so if other folks have general comments, they can make them, and then I can go back to
Councilmember
Trish.
Kitchen?
Just a quick comment. As people are moving forward to think about things, when I brought this with my colleagues back in November, I brought this because I wanted to address affordability, and I wanted to address it quickly. And I think we all did, because we all voted for it. So I appreciate that we're at this point. At that time, when we passed it in November, we said we wanted to move quicker. We put a January date on it, but of course it takes some time, and I appreciate all the hard work that our staff has done and the Planning Commission has done to get us to this point right now. So I share the sense of urgency. I think it may have been Councilmember Vela that mentioned that. I initiated moving forward with greater affordability, and I'm glad that we now have time as a group, a little bit more time with urgency, to actually get the most that we can out of this. And so I would just ask you all to think about, as we spend, a bit more time, and Councilmember Ellis, I hear what you're saying in terms of, let's know what time we're talking about. But I have proposed in my substitute a higher level of affordability, and Councilmember Renteria, I'd like you to think about this too, a higher level of affordability than our staff came back with, because I wanted to see how much we could get. Because like everyone is saying, it is really important to use the corridors and make sure that people can live along the corridors. I don't know what the right number is, but I would like y'all to think about it. What I've proposed is 15% of residential units at 60% MFI and 12% at 50% MFI. I'm also hearing that we may need even deeper affordability especially in some parts of our city. So we may need to think about a 40% or a 30% MFI. I'm not sure what the right configuration is, and I'm not trying to answer that today. I'm just trying to flag this issue of the level of affordability, the percentage of affordable units, at what level, what deep level of affordability we should ask for. And all of my colleagues are saying what we all agree, which is we need to get the best that we can. So we need all of our thinking on what that should be. So I want to thank y'all for considering that.
Councilmember Fuentes?
Thank you, and thank you, Councilmember Kitchen, for bringing this forward and having the foresight of the action that we need to take as a council. And I agree with you about having deeper levels of affordability, and so I look forward to talking more about that with you. Councilmember Vela, I did want to just share my support for your amendment related to reducing parking requirements along our major corridors. especially for housing developments. I think that, us having a conversation on legalizing parking options in Austin is extremely timely. It aligns with our climate goals and reducing CO2 emissions. And so I am supportive of that effort and would love to continue that conversation as part of our group conversations on council. And thank you, Mayor Pro Tem, for bringing that forward. I would like to join you in discussing what additional changes we can work on together.
So I'm sensing our first consensus on what we do with this item on Thursday. And I would join also to postpone this. I think it's a practical matter. We could postpone it to May 17th. That means it's back on the agenda, but without an expectation that we actually vote on May 17th, because May 17th would be the day that we're daylighting, really, for the community and the council, things that we think would work. That gives us 2 more council meetings before we leave in June, on June 9th and June 16th. And that gives us the opportunity to be able to act. In my perfect kind of world or scenario, we're able to then act on the 9th or the 16th on item 33 with whatever it is the appropriate thing to do in V, because that item is in front of us, already having been initiated. And it could be, if we're successful in finding other things to move forward, we could either have an IFC or an item from council, from staff on the 9th or the 16th to initiate other ordinance changes consistent with whatever we can agree to as part of the broader conversation. And then those can come back to us after going through the planning commission process. But that would have us maybe in fall, early fall, being able to complete this circle. So I want to ask the question, Manager, staff has done so much work on this, certainly over a 10-year period of time or more, and done just an incredible amount of work to get this back to us where we could act on it today. So thank you so much for that. I don't want staff to be discouraged at all by this being put off, but yet as a real opportunity to maybe see if we can use the work that was done as a springboard to see if we can reach further or better. And so, Manager, if we do this, we're in essence asking staff to help council offices and people between now and the 17th do that, to be able to come back, and then helping us with larger public engagement opportunities as we would head into the 9th and 16th. Can you help us with staff support to be able to do this?
Yeah, certainly, Mayor. And as always, we stand ready to assist in this process and hope that we can assure that you have the staff support along the way.
Okay. Mayor Pro Tem.
So I'd like to adjust that a little bit to be more along the lines of what we had discussed, Mayor, which is the 17th is a work session. And so you would actually need to postpone the item until one of the June meetings. We could postpone it to the June 9th meeting. That doesn't preclude somebody from bringing it earlier if we're ready. But I think we cannot have a public process if we haven't surfaced the solutions until the 17th, so you couldn't vote on the 19th. I mean, it sort of, and there are districts that have a lot of VMU, and so I just think that setting that we're going to spend significant time on the work session on the 17th, focused on this issue with a key angle being VMU, and if we manage to make progress for other parts of the corridors, we can surface those discussions as well, but that we postpone it till one of the June meetings, for the date that we'd be, voting on it, I think would be more realistic approach. And you may have meant that, I just want to clarify process-wise.
No, you're becoming a kind of a mayor whisperer today, and I appreciate that. As I'm not going, my intent was not for us to actually vote on anything, but just to daylight those items on the 17th. So we can put it on the agenda without actually putting the item on the agenda. So I think we do take the item and we postpone that to the 9th with the possibility that we would postpone that again to the 16th. And what we'll do is just put the item for discussion of council that week of the 17th. Let's see what the agenda looks like on the On the 19th, we'll probably put it on the agenda both for work session and for council. That gives us the greatest amount of flexibility, but that would be an opportunity to daylight and to talk with each other, but not to vote on anything.
As long as it's listed on the 19th as discussion only, I don't have a problem with that. I just don't want to, we risk confusing people and ourselves.
Oh, I've
More than we
confused
need
people
to.
on the dais already, so I understand the need for that. It may would just be discussion, no action. Okay, Councilmember Tovo?
Yeah, sorry, but I
You
do
had a
need
question
to.
for council?
I do, thank you. I think we moved on from that before I had an opportunity to do so. So I want to be sure I'm understanding, and I'm going to need to kind of mull over this PowerPoint. Thank you very much for providing it. And I know it's been mailed to council offices and it's going to be in the backup. So to get back to kind of the conversation that you were having and the mayor's summary of it. If we look back to conversations that we had during the Land Development Code and kind of merged it with what your interpretation is here today, if provisions in, say, RM1 are suddenly proposed to be within single-family 3 as they were during the Land Development Code, if those are regarded as text changes rather than as zoning changes, the only protest right that would be allowed would be one that is 20% of every single-family 3 property in the entire city.
Trish Link with the Law Department. I think, Councilmember, the easiest way for us to think about it is if we're changing anything in that string, that property owner has a right to protest.
Can you explain, I'm sorry to interrupt, but you've mentioned string a few times. Are you talking about the string of zoning like
CSMU.
CS, CO, NP, et
Yes,
cetera? So if
exactly.
you're changing, if you're adding something to that string, in this case it would be, let's say, SF3B.
If we are modifying that string in any way, so if it's SF3 and it's going to become RM1, and that individual property owner will be able to challenge that, protest that, and also the landowners around them.
But if you basically just put all the provision, I think what I'm wondering about as you're talking through it, I can see a natural question, and I'm surprised I don't have one already, is what are the, how are we addressing what was the primary concern of the 14,000 petitions that were filed, even though folks were told they had no protest right? If all of the provisions of a whole, what would ordinarily be another category of zoning get folded into an existing category of zoning and called a text change, as I'm understanding our conversation here about BMU too, the only protest right that individuals would have would take effect if they get 20% of every other property owner in the whole city who has that same zoning. Right, if there's not a second step. So Councilmember Kitchen added a second step where people would have to come and ask for that category. If that second step doesn't exist, the only protest right you have is if you get every other like property owner, 20% of every other like property owner in the whole city. And I just, that doesn't feel in concert with the spirit of the decision and possibly not the letter of the decision in Acuna.
So if council created paper districts, so what we're calling is, for the example, so that you have a concrete example to look at, the V2 that's in Councilmember Kitchen's proposal is a paper district. Nobody has V2. You have to, once it's passed, then you come to council and ask to be a V2, to add that to your string.
If I could pause you there for a second, that's only if we accept the amendment that she's proposed. As it is currently, it would just be by right in the ordinance that's been presented to us.
Correct, because it's changing the regulation. So all the VMU properties that are covered by that change, so all VMU properties have that regulation changed for them, is how we get to the denominator.
But I guess I'm saying you could pick any category, you could pick any zoning, under that logic, you could pick any zoning category that currently exists change every regulation within it, change the height, change the, every single regulation that's part of that, and just say, now this is a text change, this isn't a zoning change. Yet, I think, many people would probably disagree that that's with that characterization.
And that's one of the situations where we're going to have to really look at what council initiates and make that decision about how we apply state law. Because to your point, if it is so substantially different, I could see that would be a concern. So we would need to look at what council actually initiates. So what we have provided so far is just the framework of what state law says. But when it comes down to what this body initiates, what planning commission initiates, we will look at that initiation and we will make decisions and recommendations based on what is actually initiated. So for a single change, which is what is proposed right now in the staff ordinance, that would not be, the denominator will still be the total area of the V properties.
And so that, so if it proceeded as staff have drafted, you would regard that as a text change, not a zoning change. And it would have to be and the denominator would be every VMU property in the city.
Correct.
And the basis for that, is that in your estimation, the regulations within that category are not changing substantially. The increased height is not changing that category substantially enough to be considered a zoning change?
No.
Mayor? Yes. I might add in here, I do want to say that we have just, received the Acuna decision fairly recently and are still working through the details of it because it is a change in the way that we have interpreted the state law. So we want to make sure that we are continuing to review it and come up with those things and talk with council about how we're going to move forward. So I don't want to put Trish Link on the spot of having all the answers today. And we do, as Councilmember Alter had mentioned before, want to have a public facing conversation and written material so that we want to be transparent. We want the public to weigh in as well.
Okay, thanks. I certainly appreciate that. I think that is the substance. I mean, as I heard my colleagues in the conversation earlier, I think, though, this is the substance of a question that we need to be able to answer. If we are contemplating taking on this action with regard to VMU2, I think we need to be able to answer that question of why it's being considered a text change and not a zoning change under different paths. Under Councilmember Kitchen's proposed path, it is one thing. Under this proposed path, I think I'm hearing it's another, and I would like to be able to explain to my constituents. So I appreciate that a need for more time, but especially if we're now adding compatibility to that conversation, I'm going to need, I can't go out to my community and ask them to talk and to provide meaningful feedback if they don't fully understand this issue. That's just going to be the first question they have.
Got it.
Anyway, thank you.
Thank you. Mayor Pro Tem?
Thank you. Ms. Link, so when we add compatibility in there, so, I mean, as I understood what the staff proposed, it was creating this VMU2 that you could get by right if you agreed to this additional affordability, but it didn't change compatibility. Now, if you add, basically eliminating compatibility altogether, you get things, and I haven't seen your amendment, but you get things like a 90-foot building at the lot line, which is significantly bigger, and you get that then for VMU, as opposed to, all we changed for VMU, which is an existing zoning, was the level of affordability for those properties that were not already at 60%. So there is a substantive difference in the degree to which you are changing it under those circumstances. And so as you're coming back with some sense of how you would interpret things, I think that's what we're struggling with. On the substance of the particular issue, I felt very strongly that it should be by right, but that was without sort of eliminating compatibility. Now, that doesn't mean you couldn't introduce some kind of relaxation to compatibility that you get if you're doing the additional affordability, but flat out eliminating it and doing it the same level of affordability that I would have given them with no changes to compatibility, then our affordability is not calibrated and we're not capturing the level of affordability that we could on a corridor. And so you have to think about both pieces if you're going to eliminate that. And then you have to understand what is VMU's, what are the things that are already relaxed under VMU. And then a further thing for me that I'm struggling with as we do some of these things is how does this interact with Affordability Unlocked, which already lets you do a certain number of things, seems to be working very well. Do we just undermine that program as we're doing it, as we add all of these things? And that was part of the reason that I couldn't get to a point where I could support anything for this week, is because I don't understand how all these things interact. And one thing we've learned with doing zoning stuff for so many years is that the devil is in the details. And, yes, we've had, the other thing that I just want to say and why I'm excited about us having some of these conversations that kind of cross some different approaches is that we haven't actually had the conversation where we try to land in the middle. We've only had this sort of either or kind of approach. And I think there is a way forward that is more calibrated, but that still makes very significant movement. So, thank you.
Councilmember Vela?
I appreciate the Mayor Pro Tem's comments, and in some of the conversations that I've had with builders, my sense is that the reduced parking plus additional height gives room for increased affordability, either in like the percentage or in the depth of the affordability. So I do think that should be part of the conversation. But again, we do have to get it right, because I don't want to pass a program that no one uses. Whereas the current VMU program is very successful. I think we're at about 5,000 units or so on the current VMU program.
It's 15,000.
All right. And it's predictable. There's not this, the transaction costs so many times involved in the rezonings are so difficult. People, there's a big, long process. They come to council. There's these negotiations about this piece and that piece. Whereas with VMU, there's not. It's just, look, you get the height. You got to do this, and we're done. So we do have to get the calibration right. I do support the simplicity, though, the clarity. I think that will facilitate action on the ground in terms of getting additional units on the corridors.
Councilmember Ellis?
Thank you. I do appreciate those comments, one of which I had noted, and since you said it, I don't have to repeat it. But I think it's important that we're very careful about when we say something is by right versus something that is offering an added community benefit for something like added height. I also want to make sure that it is workable and usable. And so what I have heard in feedback is, when you say someone has to add this much extra to get this much extra out of it, but then you have other pieces like height, you're trying to get more height. You're adding more affordable housing to get more height. And then you have another regulation that says, but you can't actually achieve that. You can't accomplish that goal. And something I've heard over the years of talking about housing, in Austin is we can't forget that housing is a community benefit. We don't have enough housing for apartment dwellers. I myself don't own a home yet, and apartment affordability is something that's really important to me. So I want to make sure that we're careful about when we're saying, something is, by right, or they don't have to provide any community benefit to be able to achieve some of these goals, is that, we do need bonus programs that say, if you meet this criteria that's predictable and that the council has set, that we want to make sure that that project pencils out. So I really want to be careful about, even apartments, any apartments are helpful. And yes, we do need to commit to deep affordability, as deep as we can get. And I think that's why this conversation is so important for us to be having right now.
Okay, it's past 10:30, so we want to be moving over to the next presentation. For me, in case people are, I support us trying to get to something where it's written into the VMU or others so that someone knows they could get it if they do what's the obligation is. but I also recognize that it is necessarily then tied to what is it that is the accommodation or the relaxing. And for me, that's what I'm going to be working on, trying to figure out how to proceed where it is, you can get it administratively if you meet certain criteria, but doing the criteria in a way that represents an agreement, a more broad agreement. So I agree with the people that were speaking to that end. All right, Anne's going to close this out.
All I'm going to say, because we've had lots of great conversation, I appreciate hearing what everybody's perspective is. That will help us get to a point where we can have consensus. So, Mayor, you've mentioned this before in other circumstances, just for clarity for the public, since I'm feeling consensus for the postponement, that people will understand that the testimony, right, on Thursday is around the postponement. If you could just clarify that for the public, that would be helpful.
Yeah, it's been the process of the council. When it seems apparent we're going to postpone something, and we know that there's going to be a move to postpone this to the June 9th meeting, but to put it on the agenda for discussion only on the May 17th work session and council meeting that week, that the public comment would be directed toward the issue of postponement. All right. Let's go ahead, Manager, then, and move on to the briefing.
Thank you, Mayor and Council, and we'll have staff get shifted over both virtually and in person. But we do have an update on the Meadows Mental Health Policy Institute recommendations. We are joined by a number of our team here, but we will first hear from our Assistant Chief, Andy Hoffmeister from EMS. Is Andy in the room yet? We might need a 2-minute recess, Mayor.
Okay.
Could we possibly take up one of the other items that I've pulled in the meantime?
They're on their way down, so.
Kathy, let's see how many of your things we can run through if they're short. You pick. Which one do you want to go to first?
I think I'll go first to the Austin Public Health contract that's been suggested for withdrawal this week. And as I understand, this is the public health contract that we discussed last week for marketing and public relations for the COVID-19 response. I know the staff had said that they were withdrawing it because it to come up with a more variable length. And I need to understand why that's not possible within the existing posting. And I have additional questions. I'm still not understanding what the funding plan was beyond the proposed FEMA funding and ARPA funding beyond this year.
Thank you, Councilmember. We have staff from Austin Public Health, I know our small minority business group, and procurement. Who would you like to best address your question?
Well, let's talk first about the one that I think would be purchasing. I mean, I think the staff will know better who is prepared to respond to which. But as I understand the memo, it says the current solicitation needs to be canceled because to allow for a variable term and an updated annualized cost to the city. I know my staff were in communication with some of the staff on this call, and the answer was that the RFP did not include that. I thought we could always do less than was contemplated on our posting, and we very frequently have adjusted the contracts. So I'm not necessarily suggesting that we leave it on and do that here, but I'm just not understanding why in this case we can't adjust the contract length or the amount.
Mr. Scarborough, are you able to answer that question?
Yes, I am. Mayor, council members, James Scarborough, Financial Services Department, Procurement. Can you all hear me?
Yes, we can.
Okay. Councilmember Tovo, Mayor and council members, this particular item was solicited using a request for proposals process. The term included in the contract in the solicitation was established at a 5-year term. As you mentioned, we do have provisions in our indefinite quantity contracts to terminate the contracts earlier, and that provision is included in this contract. However, there were no increments included in the contract's term. This was set as a 5-year contract. So whereas the council has indeed authorized increments of contracts in the past, there are no increments in this contract to separately authorize. Like I said, it was just sought as a 5-year contract. Therefore, all of the proposals received were based on the assumption that if they were awarded, the contract would be for 5 years. If an increment of that 5-year was authorized, that may not be consistent with what was proposed, and that may throw us into new negotiations, and that may be a material change to the contract that staff would not recommend that the city pursue.
Thank you.
Chairman also understands that there were other reasons for seeking to withdraw this item and terminate the solicitation. The term was just one of the reasons.
Okay. The only reason cited in the memo had to do with the terms, which is why I was interested to know. But you've answered that part of the question, which was that there were no increments. And so then I guess my other 2 questions would be, what was the proposed funding for this beyond? As I understand, the intention from our additional follow-up with staff was that the intention was to seek FEMA reimbursement and then to utilize the $2.5 million that was in the ARPA funding. But I'm not sure that we've received any information that really answers the question that several of us asked on the dais at our last meeting, which was, what was the funding? Was the funding beyond that contemplated to be general funding or what in subsequent years? And I understand that we make those decisions on an annual basis, but I assume there was some contemplation of what the funding source would be, since it was proposed to be a 5-year contract.
Good morning, Mayor and Council. Adrienne Stirrup, Austin Public Health. Right now, there are communication projects are eligible for 100% FEMA reimbursement. At July 1st, that reimbursement goes down to 90%. And the thought was that the 10% would be covered by the current $2.5 million that we have in ARPA dollars for that. And so if you assume that we spent $3 million over the 5-year period, the amount that would be charged to ARPA over the next 3-year period that we have those funds available would be roughly $300,000. But that's assuming that it would be used in equal amounts over the 5-year period.
And the FEMA reimbursement extends across the next 5 years as well?
We don't have that information. That, comes incrementally. We get those updates.
Okay.
So there's no way to forecast out for the full period of what would be eligible for reimbursement.
Okay, thank you. I have additional questions, but I'm going to leave it there and just ask that when this come back to council, if we could also better understand why corporate PIO, I understood what APH was saying about, trying to take on the work of all of the really extensive public communications in addition to the work they were already doing was overwhelming. I mean, I'm putting words, I don't mean to ascribe, that was not the term that our public health staff used, but I can imagine that it might have been overwhelming. But I think I would like to better understand why our corporate PIO is not, how corporate PIO interfaces with departments who have particular needs during particular times, and why those, how those staff are dispatched to assist with departments that are facing, high levels. So it's not a question that needs to be answered today, but I think it does need to be answered if we have a department that is in need. Can we utilize our existing staff rather than seeking other contracts? Okay, thank you.
And then, thank you. And again, for the public, item number 18 is going to be postponed, withdrawn, so I don't anticipate any conversation about the merits of that on Thursday as well. Let's go ahead and move to the presentation. And clerk, before I forget, I would like to be listed as a co-sponsor to Councilmember Fuentes' food access item. If that's okay to be listed as an additional sponsor to your item, I'd like that to be reflected. Thank you.
And Mayor, I'm going to I'm going to try to sort through all of the information I have on item 5, just because I'm concerned that we're now going to have staff for all of these other items here all day. So I'll put 5 back on for today. I hate to have to pull it on the council meeting. I understood that 14 needed to be answered in executive session. I'm not sure why. And I would like to talk about 19 at the appropriate time.
Okay, why don't you talk to Ann here about executive session, and we can, when we go into executive session, we can call item 14. But why
Yeah,
don't you
but
let her know
again,
what your,
5,
let her know what your
I'm-
question is.
5 I'm going to try to hash out outside of this meeting.
Okay, so staff for 5 doesn't need to stay. 14, Councilmember Toe is going to talk to Ann about executive session. 18 we took care of. And 19,
Still wants to talk about it.
Yeah, I still want to talk about it.
Okay,
I
so
don't think
let's
any
hold
of these
that.
are terribly lengthy, but I do want to talk about them in a work session rather than council, so I can be deliberating.
sounds good. Manager, let's go ahead and start the presentation.
Sorry for the brief interruption.